3-Minute Lawyer, Episode 2. Jeff Amon, the 3-Minute Lawyer, empowering you with the legal information you need to be happier and more successful in just 3 minutes. In today's episode, what is probate, and doesn't a will avoid probate? We have people come into our office frequently wanting to avoid probate and asking for a will. Well, that is a false assumption. So what is probate? Well, probate is the court process of settling a deceased person's estate, whether it's with a will or without a will. So probate is either intestate or testate. Intestate meaning without a will, and state law determines how your assets are distributed. We call that intestate succession. More on that in a second. Or testate, meaning you died with a will, and the probate process is to carry out the terms of your will. Well, if you don't have a will, what happens with intestate succession? Well, that depends on the decedent's family situation at death. If the person was married, typically it's all going to go to his or her spouse. If the decedent had children by a prior marriage, or his or her spouse had children by a prior marriage, half to spouse and half to the decedent's lineal descendants. And if the decedent is single, to his or her descendants. The statute goes on to carry on to more scenarios, but the point of it all is that you want to avoid intestate succession. That is, you really need to have a will. Now, so avoiding probate is a good thing, but having a will does not avoid probate because the will is designed to be probated. So how do you avoid probate? Well, you must own all your assets in such a way that on your death, no asset is owned in your personal name. That is, there are no probate assets. There's various strategies for this, including the revocable living trust, and we'll talk about those strategies on our next episode. See you then.